and the President of the Human Rights Commission. My team and I also had discussions with Chief of Police Station in Mannar and directors and personnel of Al-Haya and Daban prisons, as well as at the Mohammed bin Naif Counselling and Care Centre. My team conducted interviews with individuals accused and convicted of terrorist crimes and met with representatives of families of the victims of terrorist offences. Over the past 3 decades, Saudi Arabia has suffered extremely high numbers of terrorist attacks by Al-Qaeda and latterly by ISIS and other groups against military, civic, and civilian targets. According to official records, there have been altogether 1,075 terrorist plots identified in the country since 1987. I was informed that 844 of these were effective, many with devastating consequences, and that 231 plots were disrupted. A total of 3,178 individuals were killed or injured as victims of terrorism over this period. I'm also mindful of many other security-related challenges and threats resulting from regional instability that the government has to face on a daily basis. The government was keen to emphasise the efforts made on law enforcement in the prevention of terrorism and safeguarding human life. In particular, government sources stressed Saudi Arabia's commitment to international cooperation and mutual legal assistance, and the introduction of strict money laundering regulation to stem the flow of terrorist financing. The extent to which such regulation and legislation is effectively implemented needs to be objectively ascertained. I commend the efforts by the government and its institutions to alleviate the suffering of victims of terrorism through comprehensive programs involving financial, psychological, educational, career opportunities, and moral support. Financial, housing, and psychosocial support for the victims of terrorism and their families is an essential part of an integrated counter-terrorism strategy, as recommended in the framework principles for protecting and promoting the rights of victims of terrorism that my mandate promulgated several years ago. I also commend efforts by the government to counter the spread of violent extremism and its associated ideologies, not only with security measures, but also with concerted action in the social, political, and economic areas. I was particularly impressed by the conditions of detention in the 5 dedicated prisons for housing terrorist suspects and those convicted of terrorism. I visited Al-Haya and Daban prisons, examined the facilities, and spoke with both staff and inmates at both institutions. The standard of care and the conditions of detention in these facilities, including medical and recreational facilities, are amongst the highest in the world. Generous provision is made for family and conjugal visits, and prisoners are encouraged to remain close to their families, being allowed to attend important family functions and even to marry in prison. Saudi Arabia can rightly be proud of the genuinely rehabilitative nature of the facilities in which it houses prisoners accused of terrorism. Particularly impressive were the unique, professional, evidence-based and imaginative rehabilitation and reintegration programs designed in the Mohammed bin Naif Counselling and Care Centre. This facility houses terrorist prisoners who are nearing the end of their sentences and provides them with a range of alternative life skills from psychotherapy to religious instruction, which are designed to entrench a counter-narrative to radicalisation and prepare them for release. The centre claims an 86% non-recidivism rate, and its methodology deserves the attention of other states considering the adoption of counter-radicalisation programmes for convicted offenders. Despite these many positive developments, I would like to share some observations, concerns and recommendations with regard to the unacceptably broad definition of terrorism and the use of the 2014 counter-terrorism law and other national security provisions against human rights defenders, writers, bloggers, journalists and other peaceful critics. I would also like to raise the continuing problems relating to the prevention of torture of terrorist suspects during interrogation, the reported use of confessions obtained by duress during interrogation, the use of the death penalty following proceedings in which there are reported due process shortcomings, and the need for greater transparency about civilian casualties in Saudi Arabia's extraterritorial counter-terrorism operations in Yemen, as well as allegations of support from sources within Saudi Arabia for armed opposition groups in Syria. Starting then with the definition of terrorism. I consider clearly that the definition of terrorism in the 2014 law on counter-terrorism and its financing fails to comply with international human rights standards of legal certainty. Any definition of terrorism should be confined to acts or threats of violence that are committed for religious, political, or ideological motives, and that are aimed at putting the public or a section of the public in fear, or to coerce a government or international organisation to take or refrain from taking any action. But contrary to that basic international human rights standard of certainty, Article 1 of the 2014 law enables the criminalisation of a wide spectrum of acts of peaceful expression, which are viewed by the authorities as endangering national unity or undermining the reputation or position of the state. I have received numerous reports about prosecution on the basis of this law of human rights defenders, writers, bloggers and journalists in connection with their expression of non-violent views. Despite repeated requests and efforts from myself and my team, the government was unable to give access to any of the individuals whose names we provided to be interviewed. I strongly condemn the use of counter-terrorism legislation with penal sanctions against individuals peacefully exercising their rights to freedom of expression, as well as freedom of religion or belief, and freedom of peaceful association and assembly. These rights enjoy international legal protection, provided they are executed in a manner that does not incite terrorism or other forms of violence. The message of international law is clear and simple. Non-violent criticism of the state or any of its institutions, including the judiciary, cannot be made a criminal offence in any society that is genuinely governed by the rule of law. I therefore call upon Saudi Arabia urgently to review the definition of terrorism in the 2014 law and to bring it into line with international human rights norms, and refrain from using anti-terrorism law and other forms of national security legislation to stifle peaceful political dissidence, criticism, or non-violent protest. I also call on the government to establish an independent national security and due process review mechanism to re-examine all cases in which individuals are currently serving sentences of imprisonment based on acts which constitute the exercise of free speech, freedom of thought, conscience, religion or opinion, or the right to peaceful assembly or association, and to commute or pardon all such prisoners with immediate effect. This independent mechanism should not be confined to examining cases under the 2014 anti-terrorism law, since many of the reported incidents of speech and opinion crimes have been prosecuted under other national security provisions. The mechanism should therefore review all crimes committed by speech or writing in order to determine whether they violate the protected rights of expression, thought, conscience, religion or belief, assembly or association. The composition of the independent mechanism should include not only a member of the senior judiciary, but also independent legal academics and representatives of civil society. My mandate is on hand in a continuing dialogue in order to provide technical advice and assistance if required, including with regard to reviewing amendments to the relevant legislation. In addition, I have this morning handed to the government a list of priority cases for urgent review. In each of these cases, it appears that the individuals are currently serving sentences imposed for non-violent speech or writing. Among those on the list is Walid Abu al-Khair, as well as Sheikh Suleiman al-Rashidi, Abdullah al-Hamid, Muhammad al-Qatani, Abdul Karim Yusuf al-Koda, Mohammed al-Bajada, Omar al-Hamid al-Said, Raif Badawi, and Fadel el-Manasif. The cases of these individuals were reviewed by the United Nations Working Group on Arbitrary Detention as long ago as 2015. In each case, the working group found that their deprivation of liberty was arbitrary because it was based on the exercise of free speech and peaceful association. That decision, which is opinion number 38/2015, is available in the room. Copies of the working group's opinion, which explains the circumstances of each individual, are available at the back of the room to explain the background to their cases. I am profoundly concerned that this decision remains unimplemented, and I call on the government immediately to release the individuals named in the working group's decision. Turning to the question of torture, I was informed by the government that there are now legal safeguards in place against torture, such as the right to legal counsel and to contact a person of choice. These rights are in principle afforded to all detainees under the 2013 Code of Criminal Procedure. In addition, prison and police monitoring mechanisms have been established within the Human Rights Commission and National Society of Human Rights. The Prosecutor's Office is charged with investigating allegations of torture. However, I am concerned about the persistence of reports of the use of torture and ill treatment by law enforcement officials to extract confessions, as well as the alleged failure to launch effective investigations based on the complaints received from defendants and their lawyers during or before court hearings. In a report published in June of last year, the United Nations Committee Against Torture expressed its deep concern at the numerous reports brought to its attention that torture and other ill treatment are commonly practiced in prisons and detention centres in Saudi Arabia. In particular, in branches of the Criminal Investigation Department of the Ministry of the Interior and in al-Mabahith detention centres. The government has categorically denied in its discussions with me that torture is ever committed on any detainee, and has assured me that all detainees are afforded all their legal rights all of the time. In light of this conflicting background and the continuing reports on the use of torture, I must express serious concern over the fact that allegations of torture or other forms of ill treatment made by terrorist suspects, lawyers and human rights defenders do not appear to systematically result in rapid and thorough investigations. I recommend the introduction of reforms to guarantee the presence of lawyers immediately as of the first hour of a person's detention, and not after permission of the Bureau of Investigation and Public Prosecutions. I have received testimonies of individuals who have never seen a defence lawyer during the entire duration of their investigation, or very late in the process, even if those persons have not reported duress during their investigation. The lack of effective guarantees against ill treatment during investigation offers the potential for torture and other forms of abuse of power. In addition, I would like to echo the recommendations made by the United Nations Committee Against Torture in its 2006 concluding observations on Saudi Arabia, encouraging the government to introduce specific compulsory training programs for law enforcement officials, investigators, prosecutors, judges, and medical personnel on the Manual on Effective Investigation and Documentation of Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, a document also known as the Istanbul Protocol. The government informed me that work is underway to implement the committee's recommendations. With that in mind, I recommend today to the government to issue an invitation for a country visit by the Special Rapporteur on Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, Dr. Niels Melsner. Furthermore, I received reports about certain due process violations in the Specialised Criminal Court involving lack of habeas corpus guarantees and trials proceeding in secret or in the absence of lawyers or in the absence of the accused. Allegations include arbitrary arrests, violation of the right to be informed of the charge, violation of the right to legal counsel, the absence of independent medical examination, the practice of incommunicado or secret detention, and the admission of evidence obtained by torture in breach of Saudi Arabia's obligations under Article 15 of the United Nations Torture Convention. It should be pointed out that the President of the Specialised Criminal Court refuted these allegations during his meeting with me, assuring me that all rights guaranteed to accused persons are rigorously delivered in each case and that no cases are tried in secret or in absentia. Accordingly, and without prejudging the merits of these allegations, I wish to highlight the relevance of such concerns to terrorist cases involving the imposition of the death penalty. In 2016, at least 50 people were sentenced to death for terrorist offences, and 47 of these were executed by public beheading or firing squad. When non-terrorist offences are included, there were 154 executions in 2016. As a matter of international law, the imposition of the death penalty presupposes the most stringent standards of due process. However, I have had to consider in detail one such prosecution resulting in the death penalty, in which there appeared to have been multiple due process violations, and there may well be others. The independent National Security and Due Process Review mechanism, which I've called upon the government to establish, should urgently review all current cases in which prisoners accused and sentenced for terrorism are facing the death penalty, in order to ensure that international minimum standards are met in each case. This means that the sentence of death may be imposed only for the most serious crimes that result in loss of life, and only full respect for the most stringent due process guarantees distinguishes capital punishment permitted under international law from summary or arbitrary execution. The last topic I'm going to touch upon in this statement relates to Saudi Arabia's extraterritorial counter-terrorism operations in Yemen and Syria, which are governed by human rights law and by the law of armed conflict. Figures held in the United Nations in July 2015 suggested that 60% of the civilian casualties in Yemen at that time had been caused by the Saudi Arabian-led coalition forces. Reliable data on civilian casualty levels for the period since July 2015 is scarce. Reports from the Yemen Data Project have suggested that between March 2015 and August 2016, 1/3 of all coalition strikes hit civilian targets, including 58 hospitals. The government informed me that it classifies the Shia Houthi rebels in Yemen as state-sponsored terrorists, and its operations in Yemen are therefore, at least in part, counter-terrorism operations. In October 2016, a strike on a funeral in the Yemeni capital of Sana'a reportedly killed 140 people and wounded 525. I was informed by the government that each such incident is independently investigated, and the results, where appropriate, are made public. I would nonetheless like to take this opportunity to remind Saudi Arabia of its international legal obligation to ensure that a fact-finding investigation, independent of the chain of command involved in any strike, is conducted by the coalition in any case where there are reliable indications that civilians may have been killed or injured, and to make the results public. I call upon the government to ensure that such investigations are routinely conducted in every case, and the true civilian death toll made public. With regard to the internationalized armed conflict in Syria, I note the significant contribution of Saudi Arabia in efforts of the coalition of armed forces combating ISIS. However, I am concerned at allegations that some of the most violent armed groups involved in jihad, which have committed serious human rights violations in that country, appear to have enjoyed various forms of support, financial and logistical, implicating sources inside Saudi Arabia, despite the government's expressed commitment to stem all terrorist financing. These allegations will need to be investigated by the newly formed international, impartial and independent mechanism to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law committed in the Syrian Arab Republic since March 2011, the mechanism established pursuant to Resolution 71/248 of the United Nations General Assembly, which is responsible for investigating crimes committed by all sides to the conflict. Finally, I would like to thank the United Nations team here in Saudi Arabia for providing valuable support throughout my visit, and I would like to thank those of you who have listened to this a short summary for your patience. I'll now take some questions. Oops. That's fine, thank you. Yes.
Thank you. Sir, I'm Ian Timberlake from AFP News Agency.
Okay.
Ian Timberlake from AFP News Agency. Sir, you referred to one death penalty case where there were multiple violations of due process. Can you please identify the accused involved?
As far as the identities of individuals are concerned, the policy that I have adopted is to raise only those that have been put into the public domain already, which is why I've named the individuals referred to in the working group report, which you can find at the back of the room. The others have been raised or will be raised confidentially with the government, but published when the report, the final country report, is published in March of next year. So I'm not naming individuals at this point, apart from those whose names I've already mentioned.
Okay, sir, thanks. And my second question is, what do you think of the bringing before the specialized criminal court people who are accused of terrorism, but according to rights activists, have just been engaged in peaceful commenting or other activities?
Well, I think I've already addressed that question in my remarks. The criminalisation of the peaceful expression of opinions or ideas or beliefs, or of the exercise of the freedom of assembly and association, is inconsistent with the basic principles of international law. So that if there are such cases, and we believe that there are a significant number of cases that fall into that category, then it is incumbent on Saudi Arabia to review them and to organise or order either a immediate release or a pardon for what are essentially speech or opinion crimes. But it is, of course, first and foremost a matter for the Saudi Arabian authorities to review those cases in line with international law, and that is why I have recommended the establishment of a new independent national security and due process mechanism that can examine these cases and ensure that those who have been wrongly imprisoned for the exercise of free speech or opinion or belief are released, and released promptly. It's important to emphasize that my relationship with Saudi Arabia is an ongoing dialogue, and as I've already indicated, there will be a full and detailed report presented to the Human Rights Council in March of next year. The opportunity exists between now and then for those individuals who are essentially prisoners of conscience to be released. That certainly is what ought to happen, and it's what should certainly happen, and happen immediately, with the named individuals in the decision of the United Nations Working Group, who have already been found by the UN to be the subject of arbitrary detention because they are being held in prison on the basis of their opinion or belief. Sorry. Sorry, I'm sorry.
محمد البخيت صحيفة المدينة. سيدي المرسل، لا ترى أن من ذكرتم في التقرير لمشروع رشيدي ومن معهم من ذكرت معهم في التقرير، ألا ترى أنهم يريدون أن يوصلوا بالمملكة السعودية كما وصلت إليه سوريا والعراق وليبيا واليمن؟ في البداية هم يطالبون، قد تكون مطالباتهم سلبية كما ينطبق الحال على الحوثي، وكانت طالباته في الأزمنة السابقة كانت سلمية. بعد ذلك نرى ما وصل به مطالباته التي كان يعتقد الكثير أنها سلمية.
In a society that is governed by the rule of law, it is essential that the basic rights to freedom of expression, opinion and belief are respected. When expression spills over into the incitement of violence, and then it is not protected, and it is a criminal offence, and it is justifiable to prosecute and punish those responsible. What is not acceptable under international law is to criminalise speech which amounts only to an expression of opinion, however critical it may be, of the state or its authorities. So the line that needs to be drawn in each case is whether somebody's speech has crossed into incitement to violence or is an expression of protected opinion and belief. That is the critical distinction to be drawn. Now, in the case of the 9 individuals that are the subject of the working group decision, the working group on arbitrary detention, which is the United Nations on counter-terrorism and human rights to Saudi Arabia. I'd like to start, if I may, by thanking the government of Saudi Arabia for having extended an invitation to visit the country. The purpose of the visit was to assess progress Saudi Arabia has achieved in its law, policies and practice in the fight against terrorism measured against international human rights law standards. This is my second visit to the country. I commend the transparency and the courteous, constructive and cooperative way in which the government initiated and facilitated this official visit and my previous working level visit in November 2016. These have allowed a frank and open dialogue to take place. I am particularly thankful to the heads of all government institutions that I've met. My team and I had the valuable opportunity to hold exchanges of views about the government's efforts in combating terrorism, in